introduced in 2012. The Youth Criminal Justice Act replaced the Young Offenders Act. The goal of the Youth Criminal Justice Act was to help youth reintegrate into society by working with communities and working with the youth to find peaceful resolutions and to help them overcome barriers. Studies have shown that youth who are incarcerated face psychological and physiological challenges and face barriers to employment and schooling and housing. However, that is the dream of the YCGA, and it is not doing enough. According to Manitoba Justice Statistics, 40 to 50% of youth who go through the YCGA end up back in jail later on in life because they are returning to the same unhealthy communities or unhealthy relationships in their lives. This is wrong. We need to do better. This needs to change, and we need to do more. We must get to the root of the problem for the youth and offer programs, services, counseling, and resources that assist the youth in making impactful changes that will alter their course of life. As social service workers, we need to support our youth and help them get to the root of their challenges to live a healthy and successful life. We must allow these youth to live up to the full potential. We are failing our young people, and we must do better.
An estimated 75% of youth in the criminal justice system experience mental health challenges, many of which are related to childhood trauma and abuse. You'd think the courts would address this better, but under Section 34 of the YCJA, only judges have the ultimate authority to request psychiatric assessments. And because judges obviously aren't experts on mental health, most of the time psych assessments are only done for those who committed violent crimes. So, what does that mean for the majority of youth who only commit petty crimes? Most will never receive mental health support, which only increases the chance of reoffending. As for the social workers, our opinions don't matter. Even though we might know our clients the best and see the need for mental health treatment, only judges get the final call in the fate of our clients. It's not a coincidence that so many youth offenders are also dealing with mental health, and it's about time the courts start acknowledging it too.
Over the years, the youth justice system has become more responsible for the well-being of young offenders as well as the public. Ask me how. Faulty provisions were amended within the Youth Criminal Justice Act, specifically detention before sentencing, also known as pretrial detention. You might ask what pretrial detention really is. No, it's not as simple, we have no other options planned anymore. Pretrial detention is when an accused has been criminally charged and detained before trial. With the development of the Youth Criminal Justice Act, a client being held in detention before sentencing is prohibited to use a course of action to deal with child welfare, mental health, or other social measures. For an example, an accused youth cannot be held in detention because they are homeless. This legislation holds the justice system accountable. Police, justices of the peace, and/or youth court judges have to find an alternative approach to detention. Instead, consider referring the accused to homeless shelters or housing support agencies. This will give clients a better chance to complete education and skills training compared to being detained and possibly learning or taking part in more illegal activity. With this legislation, the justice system collaborates more with the social service workers to find alternatives to detention, increasing their already large caseloads as more youth are turned away from judicial proceedings. SSWs and agencies will also have less time for each client in need, not allowing them to keep up with preventative measures like regular checkups, thus creating a larger workload of more difficult or priority clients, possibly leading to the SSW's burnout.
David Michael Vincent. Does that name ring a bell? This 20-year-old was killed in Winnipeg's North End on September 25, 2011. The 14-year-old, who cannot be named, under the YCJA is facing trial for the shooting death of David. This 14-year-old has a detailed history with the law. He was arrested and charged with first-degree murder in what police believe to be a gang-motivated killing. The same youth also attempted to rob a 51-year-old Canada Post man employee while showing a sawed-off shotgun, firing but missing his target on November 25, 2010. This youth pleaded guilty, and instead of the mandatory 4-year minimum sentence he would have been served as an adult, was conditionally released about 6 months after his arrest. Later than a year, he was right back into custody with the Vincent murder. If this teenager was found guilty, an adult sentence could mean that he faces a life sentence and would not be eligible for parole for 25 years. As a youth, his maximum sentence would be 10 years, only 6 of which would be in custody. Nicholas Balla, a law professor at Queen's University and an expert at YCJ, says, "I think the younger a person is, the less chance that they're going to be in an adult sentence. That is by no means certain." This case is a perfect example of how and when youth should be tried as adults. The YCJA clearly states that an adult sentence is appropriate only when it takes place after a guilty sentence is declared in youth court. The impact of legislation for the client is that they need to be aware that there is potential of being tried for as an adult, even though it is uncommon. The youth must also know that they cannot always be protected by the YCJ if their crimes are such as severity, like murder, manslaughter, etc. The clients must know that what the extent the YCJ can assist or when it is out of their hands. The impact of the SSW is that they can help a young offender to such an extent. In my opinion, a youth should be tried for as an adult when he or she commits such a serious crime such as murder, manslaughter, etc., and they need to take responsibility for their actions, or a repeated offense will occur. The youth should also receive the same sentencing as an adult would, not taking years off.
Did you know that by the time a youth turns 18, they have the opportunity to get their criminal records wiped clean so that they can find jobs more easily and do not have to be held back for their past actions? Some may argue that this is unfair. In the case of the bathtub sisters, aged 15 and 16, who were accused of drowning their alcoholic mother in a bathtub after drugging her with alcohol and Tylenol 3s, the elder daughter had then held her head underwater for 4 minutes. Their cold-blooded actions outraged many observers who felt that their sentences of 10 years, half spent doing community work, was minimal. The teens had the opportunity to stay anonymous while pursuing further education, one law, the other engineering. Does one think this is fair? If you watch the movie Perfect Sisters based on this case, the scenario is different. The girls were neglected growing up, sexually abused by the mother's boyfriends, and faced many challenges. It makes you think of the reasons why teens turn to crime. The benefit to the girls of the YCGA is obvious. They have both now taken their education seriously. One is now married, and they have moved on from their difficult childhood. The impact to SSWs is that youth now need to be given opportunities for rehabilitation and reintegration. I definitely think society is better off for this, promoting change, moving forward, getting second chances, and living up to one's full potential. Thank you.